Good morning, ladies and gentlemen, and welcome to Data Privacy Day 2020. Now, please welcome Kalinda Rana, Head of Global Privacy at LinkedIn.
Good morning, everyone, and happy Data Privacy Day. I have to say, it is really a thrill to be doing this event for the third year in a row with the National Cybersecurity Alliance, and to see the amount of interest we have from all of you. I know we've got folks who are engineers, who are in media, product, and lawyers and policymakers. And it just goes to show what an important topic we are here to discuss today, and to take some time out from our busy work to really get an opportunity to learn from some of the leaders in the field and think about some of the hottest topics and issues in data privacy for 2020. So welcome to LinkedIn. We are excited to have you here. We are very excited to partner with the National Cybersecurity Alliance and to have the great work of Kelvin Coleman's team and everyone there who's helped us put this day together. And I just want to give a quick thank you as well to all of the Microsoft employees, the LinkedIn employees, and the GitHub employees who are joining us here today, both live and on the stream. I think it really speaks to the culture our companies have created in terms of making privacy something that every employee values and knows that matters. So thank you all for your participation. And with that, I would like to introduce our first speaker for the morning, Gregory Smolnak. He is the Deputy Commissioner of the Office of the Canada Office of the Privacy Commissioner, and he's going to give us a few words to start our morning off. Thank you, everyone.
Thank you very much. Good morning, everybody, or afternoon. What time is it now? Thank you very much for the invitation to help kick off Data Privacy Day here. There's a conversation around the world that's growing louder and louder right now, and that's on how to frame privacy. It's going on in Brussels. It's going on here in California, of course. It's also going on across the continents, in Asia, in Latin America, in Africa, in fact, around the world. And there's a big debate about privacy in Canada as well. It is a historic moment, and we're all part of it. Everybody is. Every citizen, consumers are part of it, entrepreneurs, scientists, legislators, regulators, and of course, privacy professionals as well. And that's because no one owns privacy. No one owns this issue. That's because it's a shared value across democracies, one that makes our cities livable, one that makes our cultures vibrant. It is, and I stress, instrumental to both liberty and democracy. And it's increasingly under threat. In fact, I go so far as to say that the absence of privacy defines authoritarianism. Now, I'm conscious that today's theme is a vision for the future, but I'm a historian by training, and I want to briefly historicize the moment that we're in right now. My first point is that privacy is a contested concept, and it's always been that way. Privacy and how to protect it's a very, very old debate. Formal arguments around public versus private life, claims of confidentiality for personal property, legal protections for the family home as a sanctuary, no-go zones for government. These debates go as far back as Cicero in Roman times, and even further back still. Roman law was rife with debate over what fell into the basket of state ownership and control, public, versus individual actions and exchanges considered offside for government direction, private life. Similar debates occurred in medieval times around how to circumscribe the authority of the state or crown and how to modulate demands of government on property holders in private affairs. This led to, among other things, innovations such as great charters, the Magna Carta. Absolute monarchy gives way to modern democratic governance, and we see this enshrined in our constitutions. The American Constitution and the Canadian Constitution provide for fundamental legal constraints on how state authorities can enter, seize, or search private property. All that to say is privacy is not any kind of new hang-up. And it's something that has been going on, these debates have been going on for millennia. And to say otherwise is basically to paper over these centuries and thousands of years of social and legal history. That having been said, in this long history of privacy, we have arrived at a particular moment. And I think it's not too much to say that it's a critical time. And now we see privacy increasingly being considered as an articulation of risk, very serious risk. It's an obvious thing to say that businesses and governments today are confronted with and are actually themselves accumulating ever larger data sets connected to ever broader networks and systems. And this has in fact created new risks for both state interests and for individuals. It's kind of commonsensical. As organizations compile and combine ever more elaborate and exhaustive repositories of personal information, this information is reasonably being considered to be of extreme value. A lot of people refer to it as a strategic asset. So it's obvious. It's also the case that this information is being targeted by various actors. We have snooping, theft, surveillance, hacking. Interstate information warfare is on the rise. We have increased risks of intrusion, theft, loss, abuse, and other consequences. Indeed, hostile state interference in democratic processes are all growing problems. And we can cite a litany of cases from the realm of data protection alone. Multinational tech conglomerates and globalized intelligence agencies, some of the most technically advanced and well-funded organizations in the world, have not been at all times able to foil persistent attackers, even to detect terabytes of information being pulled off their networks, at least not at all times. In Canada, for the last year now, we've had mandatory breach reporting to our office, the Office of the Privacy Commissioner. We've seen about 30 million Canadians affected by privacy breaches. That's almost the entire population of Canada. And breaches don't affect only commercial transactions or impact individuals in isolation. We've seen cases that have demonstrated that privacy violations affect democracy and the integrity of democratic processes. Now, these problems are significant in themselves, and they're contributing to a growing problem of trust around the world. Survey after survey confirms this. People's trust in institutions, including in democratic institutions, is falling dramatically. As we mark Data Privacy Day, I urge everyone to use this occasion to take stock of the risks to privacy, the attendant risks to democracy, and to strengthen privacy protections, because strong privacy protections build trust, trust in commerce, trust in the economy, trust in democracy, and even trust in the future. I have one last point to make, and that's around the idea of privacy as a human right, both looking backwards and forward. Modern privacy laws developed in large measure in response to concerns over personal reputations and private affairs. For 2 centuries now, in developed democracies, new technologies have always spurred debate about new legislation and regulation of privacy. A milestone came after the Second World War, after the horrors of the Second World War, after the Holocaust, and in the shadow of totalitarianism. Privacy was recognized as a human right in the United Nations Universal Declaration of Human Rights. And this set the stage for further privacy legislation. Article 12 in the Declaration, which deals with privacy, went on to provide a basis for the International Covenant on Civil and Political Rights, the European Convention for the Protection of Human Rights and Fundamental Freedoms, and these in turn underpin the current European Union legal regime for data protection, the GDPR. I think that this point about privacy, that it is a human right in and of itself, and that it is instrumental and essential to other rights and to liberty and democracy, needs to be fully understood and integrated. It needs to be integrated into our thinking, it needs to be integrated into our laws, and into our practices. Basically, we cannot have public democratic life without privacy. The scale of the problem demands a commensurate response. Privacy must be recognized in this way. Otherwise, we don't only put individuals at risk, and that is bad enough, but our democracies as well. And it's not hyperbole. We are witnesses to these developments day by day. Now, I don't want to end on a note of pessimism. In fact, I'm quite confident that people of good faith across the world will rise to the occasion and protect their own right to privacy, understand and protect the role of privacy in democratic society, and recognize and respect the rights of their fellow citizens. I hope you found these reflections thought-provoking and hopefully useful. Thanks again for the invitation, and I look forward to the rest of today's discussions.
Please welcome Kalinda, Rana, and panelists for Privacy Across the Globe.
Give us just a moment to get everybody seated. I'm already worried about these chairs because I'm 4'11", and these are very high and look unstable. So I'm going to take my chances and ask that my panelists join me up here. All right. Yeah, they're unstable. Hopefully we look cool in these chairs. I'm gonna scoot out just a little so I can see all of you. All right, thank you guys for being patient with us while we get settled. So this panel is Privacy Across the Globe, and we are very fortunate to have 3 individuals join us who are experts in their field and also are from different parts of the globe and represent those different perspectives. So before I ask each of our panelists to introduce themselves, I just want to give you a sense of where we were thinking we would take this conversation and why we think this is such an important topic. As Gregory just said, privacy is something that needs to be thought of as a human right. And I think for many of us who've been in the privacy field for a long time, 20 years or more, it's taken a while to get a room of this size filled with people also interested in that topic. So we are making progress, I believe, in that. But at the same time, technology has greatly changed over the past 20 years so that the data we were worried about being exposed in the 80s and 90s is at a whole nother scale today and will continue to grow at a rate that many of us might find hard to imagine. So with that, global privacy laws and where this issue is headed is more important than ever. And as we're seeing over the past 5-6 years, I think first with the Snowden revelations, which really brought an awakening here in the US, and then Cambridge Analytica, which globally made people aware of just how much they were sharing and how little control in some cases we might have over our data, to the GDPR, which was passed in 2018, we've really seen an ushering in across the globe of data privacy interest and laws. So many of you may be aware that Brazil has its new law likely going into effect this summer. India has a privacy bill on the books. California, not that we consider ourselves our own country, but we have recently just passed a new privacy law here that went into effect in January. And what we're seeing is a lot of these laws following a model that we saw under GDPR. So that's something that we're going to discuss with the panelists today. So I'd like to start with Gregory, if you could introduce yourself and just a few thoughts on what you've seen the impact be in the past 2 years since GDPR has been passed in Canada.
Sure. My name is Gregory Smolinek, as you heard. I'm the Deputy Commissioner of Privacy for the Office of the Privacy Commissioner of Canada. So GDPR has definitely been influential. It's not the only model out there. We're studying bills, California legislation, bills that are being proposed around the world. In fact, there have been certainly dozens and well over 100 countries that have introduced privacy legislation in recent years. So we're looking at all of them, and it's definitely been influential. There are certain aspects about the GDPR that we're particularly interested in. Its rights basis, as you could tell from my talk, and also enforcement powers. And the prospects of it having influence in Canada are fair. There's a new government in Canada as of this past fall. It's a minority government, so we don't know how long it'll last, but they are actively contemplating updating of our laws.
Great, thank you. And Jared, do you mind introducing yourself and sharing with us what you think some of the impact has been since 2018?
Sure. So my name is Jared Ho, and I'm an attorney with the Division of Privacy and Identity Protection at the Federal Trade Commission. And some of the impacts of GDPR, I think it certainly has raised the prominence and attention that companies and firms have been paying to privacy. I also think that in a large part, it's been a great push for firms to start implementing, at least with the larger firms, implementing accountability programs and conducting the types of privacy impact assessments that we've been calling for in our agency, so that companies are better able to evaluate how their information data collection practices are affecting consumers.
Good to hear. Joao?
Yes, hi, good morning. Good afternoon, good evening to whoever is watching us, those here present. Yes, well, I'm, first of all, as a government official, I have to say that everything I say does not necessarily can be attributed to the my employer, but it's those are my own personal ideas. And I just wanted to pick up on what both of you said about GDPR, is that it has been effective for 20 months now. We are waiting for the review that will come up in May. Which is a review that was already provided for in the legislation when it was passed, to see how it's been working, how it's been implemented. And I think that the most important idea is to see that it takes time to actually put every piece, all pieces in place, and to make the whole machine run smoothly. And it's just a process that is taking place, and so we are waiting for the result of the review, and we're also waiting for the effective application by the different data protection authorities of the EU member states, because this is not about one single supervisory authority, data protection authority. It's about over 27, as you know, for instance, in Germany, there is even more than one data protection authority. So it means that the system that the GDPR instituted, this cooperation mechanism and consistency, it's really important. But it has to, let's say, to consolidate, and it takes time for this mechanism to really work and run smoothly. And with just 20 months of implementation, I would say that we are still in the early process. Again, it is a process.
You know, that's an interesting recurring theme I've been hearing at some of the conferences I've been attending globally, is it's only been 20 months, so the expectation should not be that we would already have seen significant actions. But for many in the audience who may not be as familiar as to why it is taking so long, I think a lot of people thought May 25th was going to come and immediately we would see changes occurring. Can you give a little insight into what's happening in Europe and what might be causing some of that need for a little more time before significant actions can be taken?
Well, as I said, we have several data protection authorities. Those are national data protection authorities, and with very big differences in terms of human resources and, say, budgets of the different data protection authorities. You can have, for instance, the British ICO, which is quite big, and I know they are on the way out, but still, until Friday, they're still
out of the EU.
Out of the EU, exactly.
Not out of the game of privacy.
No,
yes.
Definitely not.
Yeah.
And the thing is, like the most famous stakeholder or supervisory authority that has to deal with a lot of cases is the Irish Data Protection Commissioner. And in fact, Helen Dixon, she has always said that she needs more resources, more staff. I think they have 120, and they say they really need a lot more because they just have like 15 or 20 investigations into big tech firms. And for a small country with a small data protection authority, it's a huge workload, and you really need to have the means to get to do a proper investigation. That's why people are saying, when are the first results, the first decisions of the investigations coming out? It was supposed to be late 2019, then we're saying early 2020. This is just to show that the GDPR is like a federal law, but it's decentralized in terms of how it is implemented. And again, you have all these data protection authorities in the different countries with different means, different resources, some of them with different opinions about very important issues. For instance, cookies. There are guidelines from the Spanish supervisory authority that are different from the guidelines of the French data supervisory authority. And this means that ultimately you will have to have a dialogue in the framework or under the umbrella of the European Data Protection Board, which is this overarching umbrella organization of all data protection authorities that will have to, let's say, give its opinion on what is the correct way of interpreting a certain provision. So that's why it is not something that you say everything is written in statute, so it's perfect. There are absolutely no room for interpretation. We just apply the law, and that's it. No, and in the US, we also know that it's not like that.
I was going to ask, so I think the message that I'm hearing from you is that there's difficulty in staffing. There's also difficulty in getting coordination across various countries to actually bring these actions into play. And so I'd like to hear from Gregory and Jared, from your perspectives, from both the US and Canadian perspective. What are you finding since GDPR went into play in terms of some of the challenges that Joao has emphasized in Europe? Are you finding those in your countries as well, in terms of being able to help enforce rights for your citizens?
A big part of the discussion in Canada about new privacy law, is interoperability and interjurisdictional compatibility of the legislation. As many people probably are aware, European Union adequacy requirements also drive privacy discourses and legal reform in other countries as well, obviously in the US and in Canada. There's a curious thing that I hear from businesses. When asked, Canadian businesses that do business in Europe and are subject to GDPR compliance, when asked, how's it going? The response typically is, no problem, we're good. Then when we say, well, here's what we'd like to introduce in Canada, they go, oh, you can't do that. There's a problem with some of the features of GDPR being apparently introduced in Canada, where there's no problem in complying to GDPR if they're doing business.
So what are
you
interpreting that to really mean?
Well, I think there's probably a lot more that can be done in the Canadian context. That I think there's just a natural, I don't know if it's natural, but there's some kind of reluctance to regulation, which isn't unusual, and a kind of hesitancy. You probably see that across all kinds of spheres of regulation. But that's something I notice. GDPR, we got it, we're good. We figured it out how to operate in this environment, but don't bring any of that stuff here. But we'll have to. It's coming.
Do you think there are elements of GDPR that will be brought into Canada's approach to enforcing privacy?
Well, it's certainly part of our discussions. Canada faces a May 2020 adequacy review, European adequacy review. So this is something that's driving discussions. I think now this is very active discussion going on between us and the government. By the way, I'm not a government representative. I'm an agent of Parliament, which is independent from the government, which gives us some scope to talk about policy issues, which is different from a representative of a department or a ministry. I imagine that, put it this way, GDPR internationally has set a standard. In my mind, it sets, I think, a minimum standard. So countries around the world, there's the Convention 108, regime to which countries are signing up, which means that they're adhering to many of the features of European law or European ideas about privacy. So I think this is something that's there's more and more convergence going on, and I take that to be, generally speaking, a good thing.
Yes, and I'm really curious to hear from you, Jared, from the U.S. perspective. We've seen states trying to pass privacy laws, as well as a lot of discussion around a potential federal privacy bill. What are you seeing at the FTC since GDPR went into effect? Has it brought any changes in the way you're thinking about enforcing privacy, and where do you think things are headed in the U.S.?
Well, so I think certainly there are a number of challenges that we have to consider when we're talking about a federal framework or privacy legislation. But I would like to acknowledge that all of our commissioners have come out in favor of broad-based technology, neutral privacy, and data security legislation. I think what that means is that they've called for APA rulemaking authority for the agency, as well as civil penalty authority civil penalty authority in the first instance. As for the specifics of what privacy legislation should look like, I think our agency has taken the position that really the high-level judgment calls should be made by Congress, with the FTC having the rulemaking authority to fill in the gaps. In terms of how GDPR has affected the United States and sort of the privacy regimes here, I mean, I guess I would probably say that first and foremost, the Federal Trade Commission is a civil law enforcement agency. So irrespective of GDPR or federal privacy legislation, we have been and will continue exercising our authority, present authority to protect consumers and consumer privacy in this space. I think that we can all agree that the FTC has been extremely active this past year. We've seen a number of blockbuster settlements. We have continued to exercise our 6B authority to examine industry practices and compel, for example, most recently, 9 internet service providers and their related entities to provide information about their data collection practices and how that affects consumers. We have come off a series of 15 hearings that we've held on consumer protection and competition in the 21st century. We held a Privacy Con last year, as well as a COPPA workshop, and are in the process of COPPA rule review. So we've been extremely busy and with extremely limited resources, and so I think we've been.
I'm hearing resources as a common theme, not only on the government side but throughout privacy. So that's something that actually I would like to ask all of you how you deal with that challenge, because I think it's a never-ending challenge, quite honestly, to be able to staff up to the level that we all think might be necessary to truly do the work that your agencies or governments would like to be doing. How do you address that challenge?
So our office used to be complaint driven. Most of the work was on the investigation side of the house. About 2 years ago, what we've done is we've transformed our office to increase the role of promotion and the provision of advisory services, both for private industry and for the public sector. We also regulate our federal government in terms of privacy legislation, a separate act. And the idea is that you'll have greater impact if you provide better information about what it means to be compliant, how to be compliant, ideas for compliance, privacy by design, support, all these kind of things. You'll have greater impact. Most people in the private sector, of course, want to be compliant. They're seeking for solutions to their new initiatives. And if we can help them out in that, we'll have greater impact. So the idea there is a little bit of resource, properly communicated information, clear guidance, practical information for both businesses and consumers and government organizations will lead to greater privacy impact. maybe it's not a complete answer, but it's part of the answer. On the other hand, given the pace of technological change, the privacy impacts, second order and third order effects that I talked about earlier, the implication of privacy for democracy and other things, this is a big space, and I think it does need to be resourced adequately. Our office cannot do everything we need to do, and that probably applies to corporations as well. But you know,
it does. I'll speak on behalf of others in the room. Yes.
But maybe it's the cost of doing good business.
Yeah. So I hear from you, Gregory, you're saying you guys are applying more of an offensive role where you're trying to get in early and actually talk to companies and help them think through issues. Joao and Jared, are these techniques that you guys are applying in your offices as well?
Sure. So I should actually start off by saying the views expressed are purely my own as well. I always forget to say that. No
one here is speaking on behalf of the organization they represent. There you go.
But we really
except Gregory. All right.
No, we do apply a similar approach at the FTC. It's usually it's a three-pronged approach. I think obviously enforcement is certainly one of it's our bread and butter. It's our primary enforcement authority. But on top of enforcement, we also engage in policy work as well as consumer and business education. On the policy side, that really means that we hold workshops and convene stakeholders to understand what's going on in the industry and help provide guidance to firms as to what best practices for privacy and data security should be. On the education side, we have both consumer and business education. Consumer education is extremely important part of our mission. It helps consumers appreciate how their data is being collected and how they might protect their information. We certainly are active when there is a breach that occurs to help consumers know how to protect themselves or understand if they've been a victim of a breach. We have an identity theft portal that helps consumers navigate the process if they believe that they've been a victim of identity theft. And of course, we have business education and publish reports for firms as well.
So I'm hearing get in early, also try to educate the consumers. Joao, what are you guys doing in Europe?
Yeah, in Europe, so we have the European data protection, or rather, you have the national supervisory authorities, so the data protection authorities, with also the powers, advisory powers, the powers to send out warnings, so to have a dialogue with the controllers, with the companies. So it means that when everybody was crying, shouting about the fines of up to 4% of the global turnover, or to 20 million euros, whichever is greater. This is not, let's say, it's not the amount of the fine that defines the whole enforcement of the GDPR, because there is this back and forth, there is this dialogue between firms, companies, and the data protection authorities, and if you read the articles about the powers of the data protection authorities, of the several ones in the EU, soon to be 27 countries, they have this advisory power of having a dialogue, of sending also warnings, and not. When you look at the fines, this is really the ultimate, like the end of the road in a process. So it does not mean that immediately you will find this company without the rights of defense for this company. So it's really something that you have to see, that the dialogue is also very important. Also in the framework, this is about the powers of the supervisory authorities, of data protection authorities, and you have the European Data Protection Board, so the umbrella organization, having guidelines on specific issues of the GDPR. So far they've put out around 20 guidelines about specific areas of GDPR. Let's say the most controversial ones, or I would say the ones where there are some room for guidance, and where the companies and the data subjects ask for guidance. so yes, this is not all about fining and being the bad guy. It's really having a dialogue, because that's what companies need. You need to have like a situation where you know if you are well implementing the laws, and I think that is embedded into the GDPR as well.
Yeah. Gregory, did you have thoughts on that?
One quick comment. We're running hard, but we're not pacing technological change and the implications for privacy.
And you know, my next question for you all was going to be, I think, related to that, in that for a lot of us who are on the business side, there are challenges that GDPR presents. I think it's a very broad law, it's open to interpretation, but there are some things that may, as technology changes quickly, become outdated, such as like the consent model. I'm curious, from all of your perspective, from more of a regulatory side, what do you see as some of the potential weaknesses of enforcement for the GDPR or a framework like that?
So we know that consent doesn't always work. We're in our law reform work, we're exploring alternatives to consent as well. We're interested in European conceptions of legitimate interest, conceptions of public good. One thing that occurs to me, though, that I think would complicate our notion of public good is, and it's inspired by Zuboff's piece in the New York Times on the weekend, where she writes of privacy itself as a public good, which I think I was doing in my remarks as well, that we do have to consider the import of the various things that are in play in kind of a pluralistic way, not a relativistic way. Not every commercial interest is the equivalent of our society's democratic interests, for instance. We have to understand these things kind of deeply and, dare I say, philosophically, to be able to make evaluations. So consent's a huge thing, and there's a huge role in the future for meaningful consent. But what we have to do is understand different alternatives, different models, and see where they could be used without putting at risk the rights of people and the associated implications for liberty and democracy.
So are you saying we may need to weigh different pieces of information that are shared, or the context in which they're shared, differently when we're looking at what the framework might be for ensuring that there's some type of consent or some way of knowing whether people are okay with that?
So I think it helps sometimes to bring things down to earth and speak in terms of concrete cases, like what's the particular product, what's the particular initiative, how's that processing looking, can you get consent, is it feasible, looking at the alternatives, understanding. There's also a governance issue here too, right? Who decides what is in the public interest if you're talking about a commercial operation, right? On the public sector side, it's much easier. You have legislators and legislatures governed by democracy that make those decisions for, let's say, lawful investigation, police or intelligence services or whatever. Who adjudicates what's a legitimate interest or something that's in the public interest or the public good when you're talking about a commercial initiative is not something that we resolve. We're exploring all kinds of things. We're exploring data trusts. We're exploring different concepts. In fact, there's, I'd say, a lot of innovative thinking going on in the privacy world to figure out new approaches to how to better protect privacy, among other things, without having always to rely on consent.
Yeah. Jared, Joao, do you have thoughts on that?
Sure. So, I mentioned earlier that we had just rolled off a series of 15 consumer protection and competition hearings. And at our privacy hearing, among the stakeholders, notice and choice certainly played a prominent feature and part of that conversation. And what I think I heard from our panelists at that event was sort of agreement around this idea that this current notice and choice model can often lead to information overload and confusion for consumers, to be honest. I think that that's to say that really, this model or practice of long-form privacy policies coupled with opt-outs can impose significant burdens on consumers to read those policies that may sometimes be too vague for them to fully understand or appreciate. I think we also heard from our panelists and commenters that we should be thinking about or concerned about practices such as the use of dark patterns to essentially exploit consumers or manipulate them into exercising type of choice that they might not necessarily otherwise have engaged in. Our panelists also mentioned this idea that there is fear and anxiety out there from consumers about how their information is being used, and that can lead to chilling effects with respect to consumer conduct. And so I think that going forward, notice and choice really is going to be a significant challenge that we're going to have to address head on. What are the processes for us to provide upfront, meaningful consent choice mechanisms to consumers? How are firms going to be able to foster trust in a manner for them to continue innovating and providing benefits using consumer information?
I think many of us are struggling with how to make consent work on a mass scale when every piece of your life has actually got a piece of data attached to it, and it is happening on such a frequent basis. How does notice and consent work? How can you manage it? And as a parent of 3, I find it hard not to just manage it for myself, but for my children as well. So before we turn to you, Joao, for a reaction on that, I just want to let everybody know in the audience, if you have questions and of the panelists, please come up to the mic. There's a mic in the back. And I do want to open it up for questions after we hear back from Joao on his thoughts.
It's very brief because I think it's really important to have questions from the audience. It's just to say and to stress that the GDPR is based on processing of data using legal basis. So there's an article that says when you process data, it can be on the basis of consent, execution of a contract, legitimate interest, a public obligation provided for law or regulation. So it means that it's not all about consent. And of course, that's the companies, or say, of course, no. I would say that most companies, when GDPR became applicable, starting to play on the safe side and ask for consent when, in some instances, it was not strictly necessary to process data. It could be in the framework of the execution of a contract, and I guess that's the difference with the Ccpa, because I think in California there is not a list of legal basis for processing data. So again, the notice and choice is heavy, or it's really predominant in the still predominant in the US. So this is just to say that even if consent, yes, it's really important, but it is not the only legal basis for processing data under the GDPR. But fully understand that it's still a substantial part of the processing.
And I think it's an important point to make. It is not the only basis. I think the thing that is difficult with it, though, is it is the only basis that the end consumer sees and interacts with. So while on a business side, you can rely on these other bases, a lot of the public's not seeing that as much.
Just a really final remark. It's that in some cases when you have the cookies, it's not so much about the GDPR. It's another piece of EU legislation. Sorry, guys, which is called the Privacy Directive. So about the placing of cookies, and it's an obligation under that directive to ask for consent, and it's a directive that it's currently being reformed in the EU, but. Again, so it's not only about processing of data, it's really about placing of cookies in your equipment, and so it's broader. So this question of getting consent is broader than just about processing of data, which is strictly the area, the remit of the GDPR.
Good point. All right, I see that we have some questions from the audience, so would you step up and to the mic?
Thank you, Kalinda. My name is Lan Jensen. I'm the CEO of a nonprofit, Adaptable Security Corp. I also wear some other hats to help with the NIST DHS-led initiative for smart cities. And locally, I also am on the board of directors for the ISC Squared Silicon Valley chapter. So from my multiple hats, one question I want to raise for some insights from you, Kalinda, and your panel, is that we know it's essential. Already it's mentioned it's human rights, privacy is. However, when we try to spread the word to the community, it's just so darn hard. I have to admit that I do not read all of the privacy statements myself. If it's a reputable company like Google, so I'm like, okay, darn it, some other people more capable or have time to do that will already have done it for me. So I skip through, right? Because otherwise, it's just unbearable burden for every single person to have to read through those statements. So my question is, do you think there possibly could be a way to make it simpler for ordinary people to consume and digest? Is there possibly a killer app for that? Right, so the statements could be say, hey, I'm compliant to category A, I'm compliant to category B, and then people instantly know. They only need to know what category A stands for. So just a food for thought on that. And then my second point is a comment about the cultural differences playing a role in privacy as a human right as well. I know that in some parts of the world, it's unrelated to policies or politics, just the cultures could have different concepts for privacy. So my question on that is whether you think privacy could also be adapted to different cultures versus one big umbrella. Hey, everyone needs to come under this umbrella. Thank you. I'll take
Thank you. So for your first question, I think it gets back to that discussion we were having around notice and consent. And we all know there have been attempts to try to simplify the notice process by having seals on sites, by the nutrition label concept. There have been multiple ways. Jared, I'm curious to hear from you specifically on from a U.S. perspective, what do you think the answer is to that issue?
I think everyone is sort of right in that, notice and choice, and this came from our hearing as well, is that notice and choice by itself does pose significant burdens on consumers, and so it can't operate solely by itself. And so, there certainly is something to be said about accountability, corporate accountability programs and privacy impacts assessments, and as ways for firms to evaluate how their data collection practices are impacting consumers. So I think that's sort of one mechanism. Our agency has talked about just-in-time notices, and part of Section 5 is that material statements have to be clear and conspicuous. So there certainly are mechanisms out there. We have guidance on sort of how to effectuate notice, and so you can visit our website at business.ftc.gov if you would like more information on sort of our best practice guidance there. On the consumer side, and sort of this idea of like information overload, I think that is sort of spot on. It really does put a lot of onus on consumers to be able to sort of appreciate and fully understand all these things. We do have guidance out there again for consumers to sort of streamline that process, and we sort of do our best to help educate folks on that.
Yeah, I think it's a challenging issue and one that many of us need to be thinking about solutions for more. On your comment on the human rights issue, Joao or Gregory, do either of you want to take that one?
Yeah, no, I'm just from the EU side. Of course, the right to privacy and right to protection of personal data is one of the rights enshrined in the European Charter for Fundamental Rights, and it is something that we really praise. And it's one of the aspects that, for instance, in the framework of Privacy Shield, which we're not going to tackle today, is being looked into really. So about how the protection of these two rights and the right to effective remedies is ensured and safeguarded in the US. So just to say that probably in the EU, we are the ones most at ease with the human rights dimension of the right to privacy, private life, and personal data.
And given our timing, I was going to move on to the next. Do you have
Quick
something
comment.
to say? Yeah.
Diversity is both a fact and a value, but diversity is impossible without unity, and I believe in the universality of human dignity, which makes possible human diversity.
Very good answer. I like that. Next, yes?
So just following from that, so my name is Ashwin Krishnan. I run a small cybersecurity training company called Uber Knowledge, but I spent a bulk of my time as a podcast host. I've interviewed about a bunch of CISOs and chief privacy officers, but I'm not in the capacity of that. I'm asking as an uninformed California consumer. I have exercised my CCPA rights with 3 organizations, and all 3 sucked. User experience. In fact, right now I was going through one of the most popular gym clubs in the state. And as was essentially an email comes, I click that link, go to another website, I have to scroll through about 20 pages, and I get to the last page, and I see this column which says, they capture audiovisual information of the gym. For marketing purpose, they sell that information. They also, and this really got to me, is they make inferences based on my heartbeat, my weight, my height, and they sell that to a third party. And please click on this if you want us to stop doing that. Click on that. 45 days later, I'll know whether I was approved or not. So my question to this esteemed panel is, yes, we're talking about GDPR, talking about CCPA. It's been authored by legal counsel and lawyers to protect the company. It is not consumer friendly. Again, going back to my esteemed colleague's comment over here, how do we solve that? We're sitting in this room, obviously there is a lot of audience over here who are trying to kind of do the right thing, but 3 organizations, and I still don't know where I stand. The 4th organization just spooks me. And knowing, I'm even wearing my tech hat, I had no freaking idea they're actually using AI and ML to actually predict and sell that information. So I'll stop there. Any comments?
Well, first of all, I hope I'm not a member of your gym. I'm concerned.
It's a very popular gym, so.
But I'll turn it over to the panelists. A reaction to that, that's a great question.
I can start out. I mean, so I can't comment on the specifics of your situation, but I think this really drives home the point that there is fear and anxiety among consumers about how their information is being collected and used. And we do need to do a better job and consider frameworks that are able to offer upfront, meaningful choices to consumers. And I think that we've sort of reached a stage where consumers have notice fatigue. They're being over permissioned, and so there has to be, when we're thinking about frameworks moving forward, there has to be mechanisms and safety valves for consumers on those aspects.
Gregory, did you want to comment?
Well, better laws in more jurisdictions is one thing, but there's frankly a political dimension to this as well. There's people can't be complacent about these things, and sounds like there has to be an associated call to civic and political action as well.
I don't want to answer the question directly because I realize I'm the moderator, not a panelist, but I will say that I think there is a responsibility amongst the general public to become aware of these issues and to take a stand when companies are reacting in that way with the way they're handling data. And I think the days of these very long notices where you would consent to everything and every right of everything you've given is handed over are changing. And I think the expectation is that more and more companies also begin to act on those issues more ethically and thoughtfully, but certainly you should quit your gym. Next question.
So this is somewhat related. My name is Mike Katz. So the U.S. is a signatory to the UN Declaration of Human Rights, and obviously Article 12 provides for right to privacy. what are the practical implications in the US of that right to privacy in an age of surveillance capitalism where I don't have control over my data? I don't own my data.
Anyone want to take that one?
Well, one of the things I've noticed is when I make a pitch like I did today, that to make sure that people integrate into their thinking, into their actions, privacy is a human right. Some will say, well, we can't do that. And I point out, well, it's in the UN Declaration. So I'm not actually debating it. It is a human right. The question is, how do you operationalize that? And it's a combination of all these things. It's a combination of the answers to the last question about what about my gym and what can I do? I mean, it necessitates a combined response from the individual citizen, consumer, regulator, government officials, legislators, corporate officers, et cetera. The absence of the recognition of a right does not trivialize that right. There are jurisdictions in which all kinds of human rights are violated in probably even more egregious ways than some of the things we're talking about. Doesn't mean that right doesn't exist. The question is, how do you bring about the recognition and implementation of those rights? That's a super complex question. But I think we need to bring prominence, sunshine and light to the issue, recognize it as such. We're proposing that there are preambles and clauses in hopefully our future legislation that will include this rights basis, that will then bring about additional jurisprudence that recognize this. Don't forget that also, correct me if I'm wrong, but I'll speak of the Canadian context. Privacy is a quasi-constitutional right as well, right? There's the search and seizure implications as well. So just more prominence, more education, more recognition from everybody.
So I think we have time for one quick question. Yes?
Good morning. I'm Hiten Patel from Color Tokens, a cybersecurity product and also a compliance product company. I have a simple question. GDPR rules and regulations ask companies to have their customers opt in for managing and storing and selling privacy data. Ccpa wants consumers to opt out, so by default they're opted in. Why did America decide to go this route, which is different from lots of other parts of the world? Most people are going for opt-in as opposed to opt-out.
I think you've highlighted a great conflict between the two and an important question. And we actually have a panel on CCPA coming up. So I would encourage you to ask that question there, because I think that would be really helpful to get some folks who are experts on CCPA to answer that. I am getting the signal we need to wrap. So I'm going to thank our esteemed panelists for a great discussion. And thank you also to the audience for being so involved with such good questions. Thanks, everyone.
Please welcome Larry Magid, CEO of ConnectSafely.org, and panelists for CCPA and the Wake of Privacy Legislation in the U.S.
Okay.
Like a director.
Get a little rhythm going.
Good morning. Am I on? I think I'm on. Hello, everybody. I'm going to have the panelists introduce themselves, and then I'm going to quickly introduce myself, and then we will begin the panel. So, Tom, why don't we start with you?
Good. My name is Tom Pendergast. I'm the Chief Learning Officer with MediaPro, and we're a cybersecurity and privacy training and education company.
I'm Stacey Gray. I'm a privacy attorney in Washington, D.C., and I work for the Future of Privacy Forum, which is a nonprofit policy shop, and I lead all of our state and federal legislation outreach and analysis efforts.
Perfect. And my name is Thomas Hallett. I lead up the privacy solutions engineering team at OneTrust, which is a privacy management software company.
So I'm Larry Magid. I'm the CEO of ConnectSafely.org, which is a nonprofit internet safety, privacy, and security organization. If my voice sounds familiar, you may hear me on CBS Radio. I'm also the CBS News technology analyst, so I do a lot of radio often about subjects related to privacy and security. And as long as I have the floor, I'm going to give a brief invitation to everybody here. Next week, I should say February 11th, following Data Privacy Day, will be Safer Internet Day, a global event that's celebrated in 140 countries around the world. And Connect Safely is the US host of the event, and we are having an event at the Computer History Museum in Mountain View during the day, which is largely for high school students. We'll have 300 high school students from around the Bay Area, but we are inviting policy wonks and technology company executives, et cetera. And then we're having an evening event that night, the night of February 11th, at the TikTok offices in Mountain View. It's for parents and children and teens and whoever. I'm not running that event. It's going to be run by teens who are going to be teaching parents how their kids can safely use various apps like TikTok and Snapchat, Instagram, et cetera. So if you're interested in attending either of the events, there are limited seats available. We're filling up. You can go to SID2020.org, and you can read about it, and there is a registration area there. So with that over, let's turn to privacy. And specifically, I want to welcome you to California. How many people here are from out of state? Okay. Well, California is the land of well-meaning legislation with unintended consequences. I know that firsthand because, as I mentioned, I am a technology journalist, and CBS News has turned me in from a freelancer to an employee, which has some benefits and some drawbacks. And the San Jose Mercury News is asking me to form an LLC, which will cost me thousands in fees, legal work, and taxes over the years. So thank you very much, State of California, for protecting my rights and wind up having to cost me a great deal of money and aggravation. I actually liked it the way it was, but they are protecting my rights, I guess. So that's kind of an introduction. I'm not saying that that's also true with CCPA, but inevitably, when you have a piece of legislation that is that broad, it's going to have probably many positive effects, but possibly some negative effects, not only on the companies that are asked to comply, but potentially even on consumers. And that's something I want to explore today. But mostly I want to talk about what the impact is going to be and how companies are complying and where we're going from there. So it's the broadest legislation a US state has ever enacted. It went into effect in this January 1st. Starting, I guess, with Tom at the end, why don't you discuss your understanding of its impact on both businesses and consumers?
Yeah, thank you. One of us will be the other Tom. So this law is going to be a bellwether for all the other states to follow. Well, at least a number of states to follow until they prompt the federal government to do something on their own. But it's also, I think, a pretty clear signal to lawmakers at all the different state levels that they need to be thinking about what they're doing, to businesses across the nation, that if they haven't gotten their data house in order, the time is coming when they need to get their data house in order. And to the consumers who are paying attention, and I think thanks to a lot of the reporting that's been done in the New York Times and Consumer Reports and Washington Post and you name it, there's so much more awareness about privacy laws and the individual's rights. It should also create a groundswell of interest among consumers in seeing things happen in their own state. So for me, it's just an instigator to this happening across the nation.
You know, you mentioned getting their house in order, and that reminds me of a survey that took place last year, which found that 1/3 of executives didn't know what to do in terms of complying with the CCPA. 44% hadn't even heard of it, and half hadn't modified their behavior around GDPR. So do anybody have any updates as to what the current state of readiness is, given the fact that the law went into effect nearly a month ago, and what is being done to make sure that businesses know how to comply? Any of you can take that.
So go ahead, Thomas.
No, I was just going to say, yeah, I think obviously the law came into effect, and what the law was really good at was shining that mirror on internal organizations to start, even just starting on the process of getting the house in order. It was mentioned in the talk earlier that although we're 20 months past GDPR, organizations aren't technically meant to be there. They're not fully kind of got everything documented, everything outlined. So although organizations, some of them aren't aware or they haven't changed, it's definitely shining that light on that they need to, and they need to start on that journey. So
Stacey, you're with the Future Privacy Foundation Forum. Can you talk about what educational projects are going on to help businesses better understand the law?
To help businesses better understand the law? Well, I can tell you my perspective on CCPA, which is that I think the sort of lurking secret about CCPA is that despite all of the tremendous compliance costs, which I don't by any means want to invalidate, but the compliance costs associated with the law that isn't quite that well drafted, that people don't quite know what it means, it's not quite interoperable with global standards. Maybe it's a first for small companies to even have to do data mapping at all. Despite all of those costs, it's really not that strong of a law for consumers.
Yeah.
It does like three things. You can access your data, you have a right to a certain degree of transparency, which we all know people don't read privacy policies in the first place, and you have the right to delete the data and request to opt out of sale. And the problem with an opt-out of sale, which is a unique thing in American law, it doesn't exist in other privacy regimes as a standalone thing, is that it sounds good, it's very rhetorically effective, but it doesn't reach a lot of the things that people expect it to reach. It's both over and under-inclusive at the same time. So you have large tech companies like Google, Facebook, LinkedIn even, saying, we're large first-party platforms. We don't sell your data. We have insight maybe into data about you from sort of a wide swath of sources, but we don't sell it to anyone because we're a first party, even while we might be doing personalized advertising and things like that. And then for advertising intermediaries, they are maybe transferring data to service providers that are acting on behalf of both them and the advertisers, both advertisers and publishers, right? So I think people expected an opt-out of sale to be something different than it ended up being. And it ends up, you have companies now, Tom, you can speak better to this, that have an opt-out of sale and opt-out of behavioral advertising, and they're separate.
And even on the behavioral advertising, I think Google is working towards the abolition of tracking cookies, yet it still has the ability within its own advertising network to measure behavior, yet at the same time. And I don't know if anybody can explain that on a technical standpoint, but I find it a little baffling.
So it's a blunt instrument, and I think as soon as it went into effect, people started realizing that we need more. So if anything, it's setting sort of a very low baseline that's nonetheless difficult to comply with for companies. And every law that we've seen introduced since then, the Washington Privacy Act, a lot of the CCPA copycat bills that we see across the country, the California ballot initiative that will be on the ballot this year, this November in 2020, they all go way farther.
You know, it's interesting. I know a lot about the Children's Online Privacy Protection Act, CCPA, and it had a severe impact on a number of smaller companies that couldn't comply, some of which had wonderful children's services that they had to basically drop, yet the larger companies were able to either comply with it or simply just, establish a 13 and up. So, I mean, is there that risk with CCPA of hurting smaller companies and bigger companies doing just fine?
I think there's a risk with any privacy regime that has compliance costs associated with it, that smaller companies are always going to have more challenges with that. I think you can start to solve for that if you're looking at this as a lawmaker by thinking about things like small business exemptions, safe harbor programs, but above all of that, just clear rules. I think what I see from small companies is just give me a very clear rule, even if it cuts off some potential business model or source of revenue. The clarity is a cost-saving measure in itself.
Tom?
So Larry, I want to go back to your original question, which is why aren't businesses acting more speedily to pull this together? And it goes back to something that Gregory said in the previous panel, which is that the gears of regulation and enforcement, like the gears of history, grind really slowly, right? So we saw the GDPR come out and everybody thought, oh, we're going to immediately see big fines. It's 2 years now, and we hardly have seen any. The same thing is going to happen with CCPA. It will take a good bit of time before enforcement activities come into play and really start nudging all those companies who've decided that they maybe wasn't even a conscious decision, but decided they could sit on the sidelines, or maybe they knew they wouldn't be the initial targets of enforcement, and so they could wait. If we think that this change in privacy is going to impact the whole world right away, it's not. It's going to take some time for us to change the entire culture around how businesses approach privacy and how individuals understand the reclamation of privacy rights that laws like this give back to them.
Thomas, did you want to comment on that?
Yeah, it's just an interesting point around how organizations are trying to understand the law and kind of go through it. I speak to a lot of organizations in kind of my role. Everyone's asking the same questions. People are asking, oh, what's everyone else doing in the market? What do I need? How big's the privacy team in all these companies? Like, do I need a cookie banner at all? The unknown is kind of the biggest thing, I think, that's stopping people from starting as well. And it goes back to the legislation's not being quite descriptive enough through them. I still don't think we have a full definition of what the sale of information is. So everyone's understanding it in their own way, and cookies is falling under that banner. So I think education and kind of training and just understanding over time, even the legislators themselves need to get that kind of understanding as well.
So one reason we're talking about CCPA in a national forum is because California is, I think, the world's fifth largest economy. It affects essentially everyone in the United States and really everyone in the world on some level, especially given the presence of all the tech companies here. But another large economy is Europe. And a number of you have mentioned the GDPR, the General Data Privacy Regulation, if I have that right. That's also having an impact in California and throughout the United States. Just yesterday, I got probably the 1,000th email from some company to recognize that I had to agree to something to be in compliance with GDPR, even though I have no idea what I agreed to. I clicked on it anyway. I think I gave up all my privacy rights or whatever, not sure. But all I know is that we have these two very large economies with different laws. We have no federal legislation. We have no global legislation. I'm not sure we ever will have global legislation. But let's start by talking about the differences and similarities between GDPR and CCPA.
Yeah, I think I can start with that one. So it's interesting to see as organizations implement measures for CCPA, those that already comply with the GDPR and went through that process a couple of years ago are very much on the front foot to that. So although there are kind of big differences, the amount of rights that consumers have in California is less than European citizens have in kind of Europe as well. But although there are differences, I think as you kind of comply with the likes of the GDPR, it sets you on the front foot to then go through these legislations. And I think we might see that across the rest of the US as well when we start to go through this these other laws, is that if you start with that big foundation of maybe the most comprehensive in the terms of the GDPR's got kind of more in it than the CCPA, it helps with these additional laws as well through that.
Any other thoughts about GDPR versus CCPA?
It's true if you've done your GDPR lift, checking the boxes for CCPA should be relatively straightforward. But I think when CCPA came into effect, a lot of people were comparing it to the USA's GDPR. Oh, it's global, it's comprehensive privacy legislation. The two laws could not be more different. I mean, just in scale and in substance, in what they do, the CCPA has a few relatively limited individual rights. The GDPR is comprehensive. It does not rely solely on consent, like the last panelists were just talking about. It has a legitimate interest, lawful basis to collect data. It has lawful bases to collect data at all, which is something the CCPA lacks. It has data protection by design and privacy by design requirements. It has auditing requirements. It has automated decision-making requirements, prohibitions against sensitive data use, prohibitions against automated decision-making using those sensitive categories. So many other things, many of which don't rely on individuals standing up for themselves and exercising their rights. So the laws really couldn't be more different.
And yet one of the problems we face is that there aren't enough privacy professionals in the world to sort out the difference in companies, to sort out the differences between these two big laws and all the other state laws and maybe a federal law that are going to come around. At some point, if we're going to enable global or even interstate commerce effectively, we're going to have to kind of come to some shared principles that enable data to flow across all of the borders that data will flow across.
Well, that's a perfect segue to my next question, but I just want to make an observation that, as I recall, GDPR was negotiated over a period of years, and it was a huge undertaking. As I remember CCPA, it was put together very quickly in response to trying to stave off a a referendum. The legislature put together this law in a matter of, I think, days or weeks. It was very, very much more limited in the development than GDPR. But getting back to the point you made, and we've all referenced, it's a patchwork of laws. If you're in Arkansas, do you have different rights than if you're in Oklahoma or California or, for that matter, Paris? And so let's talk about how we can, what the impact of this patchwork is on both businesses and consumers, and what, if anything, can be done about it.
I won't speak for Microsoft, but what I've observed Microsoft do is they build their policies and their practices around the highest global standard, and they behave that way across all of the different domains where they do business, which are probably all of the possible domains in the world. I mean, if I were running a company, that's what I would do too. I would adhere to the highest principles and not attempt to wade through all of the sifting of the various conflicting claims made by these laws. That's a tangential answer to your question, Larry.
Any other thoughts?
So we obviously need a comprehensive federal standard, right? This is what FPF has been among the many calling for a uniform national standard. And I think many of the reasons there get into definitions of key terms, how you define personal information, how you define what it means to properly de-identify information, what it means to transfer information, what it means to sell information. These are the kinds of things where if you have slightly different definitions and structural differences between state laws, you're going to have major problems with your data mapping and compliance across different states. That said, I think the push from industry right now is we want to have a federal law that preempts everything and no states shall regulate on privacy ever again. And that's probably also not going to be totally practical. I want to point out there's a great deal of what I would call sort of legal innovation happening at the state level. States are better positioned to respond quickly, particularly to new technology or in times of a crisis. You saw a lot of this, for example, after the AIDS epidemic, there were HIV disclosure laws passed in a lot of states very quickly to regulate the disclosure of that new sensitive type of information about people. You see state laws related to not allowing employers to demand social media passwords. Pretty unobjectionable, doesn't necessarily conflict with a comprehensive framework, right? So I think we're gonna have to find a way to set a uniform national standard and acknowledge the reality that states are always going to have their own slightly different, states have different privacy tort law, for example.
Well, I know there is some federal legislation, I don't know in exactly what fields, which actually preempts state laws, which basically says you must comply with the federal law and the states cannot make it any stronger or any weaker. In fact, there's a debate over emission standards, with the Trump administration wanting California to essentially weaken its laws to be in compliance to what the administration wants to be the federal law. It strikes me that those laws, on one hand, do clarify and create a level playing field and make it easier for companies to do business across the country, but the other hand, they deny state legislators or the people of individual states the opportunity to improve or increase the rights within their state. And how does that work in a privacy world, especially, again, since most of the companies are operating at least throughout the country, if not throughout the world?
That's 100% the heart of the last remaining barriers to having a comprehensive federal law. It's down to two things. How will the law be enforced, which I think is a bit of a more approachable question, even though there are strong political views on each side. And preemption. To what extent should it preempt innovative state measures? The answer is going to be it's going to have to preempt some. And then the harder questions are going to be around things like who is the federal government to tell a state that they can't tell their own law enforcement officers, for example, at the local and state level, that they can't use facial recognition technology?
Yeah, what would happen if North Dakota passed a really, really strong privacy law and nobody else in the country, including the federal government, had that law? Would Facebook and Google and Microsoft and all these large companies, how would they handle it?
Geofence out
few
North
customers
Dakota?
they have in North Dakota.
It's a good question, and it's, I guess, lucky in that sense that we started with a large economy like California. What we're seeing is a lot of states like that trying to pass sectoral laws. So we saw Illinois actually passed, and then it got vetoed by the governor, a geolocation collection, use, and sharing law last year that may come back. And I think with something like that, companies would have had to level up. But the more of these that you start seeing, I mean, we had, 19 bills introduced last year. None of them passed. Well, 2 of them passed and got vetoed by governors, but none of them effectively passed. This year, just in January alone, my count was over 700 privacy bills introduced at the state level related to privacy, data collection, biometrics, AI.
So if anybody's looking for a new career, I think becoming a policy wonk for a company for all states, there must be plenty of jobs open in that area.
And some of them don't necessarily conflict with the comprehensive regimes, right? So one of them that had a hearing this morning in a committee in the state of Washington is called the AI Profiling Act, which is worth taking a look at. It's like 2 pages long. It's totally approachable to read, even if you're not a lawyer. And it deals with public spaces in the state of Washington and whether companies should be permitted to use artificial intelligence through cameras to make decisions about people based on their appearance, not their identity, but things like gender, race, right? So not strictly speaking an identity or a privacy-specific law, but a law about the kinds of protections and the kinds of inferences that people should be able to make about us in public spaces.
Yeah. Tom, you look like you wanted to say something. Yeah, no, it's interesting. I think AI is a great example of a technology that even people within the technology world don't fully understand and can't fully agree on what the parameters of it, but is obviously going to have a huge impact on all aspects of society, especially privacy. So I guess let's talk a little bit about the consumer. I mean, we've talked a bit about businesses, and Stacey, you've kind of referenced that, consumers are getting some rights under the Ccpa, but maybe those rights may not be as meaningful as some people think they are. How do we, first of all, engage consumers to understand that they should be thinking about their privacy rights, get them to understand in a realistic and meaningful way what are privacy threats and what aren't, because a lot of things people are paranoid about turn out to not be true. I constantly hearing people in my family complaining that Google is listening to all of their conversations and is sending them ads based on things they're saying, even if the phone isn't even turned on, which would be a good trick. But yet, at the same time, there may be some major privacy things, risks that we're taking that many of us aren't even aware of. So starting with kind of consumer education and then getting into how do consumers protect their own rights once they understand what they are.
Yeah, I think it's interesting on the education part and also how organizations approach the consumer. So a big thing across Europe when GDPR hit was every single person, every single organization that you never knew had your data sent you an email that said, here's our new privacy statement, please can you accept it? And everyone was kind of, I didn't even realize you had that. So I think the fact that organizations have to have that disclosure, again, tells you, okay, this is where my data is, gives you a bit of that understanding of, I need to consider actually where I put my password in. When that pop-up comes up and says, do you accept to this? Actually, what is that doing? So I think a lot of this legislation has that kind of understanding and those disclosures to put that in front of the consumers.
It reminds me of those signs in every business of California. You walk into any lobby and you're going to see a sign that there are something known to the state of California here that's going to cause cancer, right? So if there really was asbestos falling off the walls, would they have the same sign? How do you know, given the fact that these signs are literally everywhere, what actually is a cancer risk versus what's just a compliance sign? And I'm wondering, as you bring up this issue, similar with privacy, how do we know? Few of us read all of these privacy. I mentioned yesterday I got a message from some site that I almost never use. I would have spent more time reading their privacy policies than I'm ever going to spend on that site.
Yeah, I think it's interesting. I think it's the equivalent of the online version of that sign is the cookie banner. I don't know, has anyone actually clicked into a cookie banner and read what cookies are on that site or even know what a cookie's doing on that site?
Yeah.
A few people, but the majority of people who access your site just see that as a nuisance. Press accept, don't read it, and just continue. I work in privacy, and every time I see a cookie banner, I just press accept and just
We actually had one hand up, which considering this audience, if you were to do this in any other audience, you would probably get no hands. So.
Exactly. So I think the idea is at least it's there so people who are interested and want to go through it. I think the actual change of people's perception of privacy online is going to be a very unique thing to each person and how they want to interact with it. So I think it's good that at least we've got that there for those people that want to see it and kind of work with that.
Yeah, if you look at that big Pew Research Center study that was done last year, they showed that most people, most Americans in this case, think that privacy is already lost. Corporations already have all their data. Governments already have all their data. That tells me that we've got a lot of work to do in this country if we're going to reclaim the idea that individuals have any control at all. And I actually think that businesses have a huge role to play in that, because as businesses seek to come into compliance with these various laws, they're going to have to educate their employee populations about their roles and responsibilities. And it just so happens that most of those employees are also citizens. So I think there's a way that the way we educate employees in the workplace can start to change those viewpoints. The work of all the reporters, reporting regularly on privacy issues can start to change those viewpoints. It's not going to be that suddenly everybody's going to notice that there's a privacy banner or a cookie banner and they start to read it. Those things, they annoy the heck out of everybody. But I think there will be sustained, and it'll take a long time, but there will be cultural changes that will make people more cognizant of their rights.
Yeah, and I think it's really interesting, and it's where we're seeing privacy, and it's a big topic that we're kind of talking about as a company, is around it turning into ethics. This is no longer just a legislation thing. It's no longer every state that comes out with a law, we're going to comply with it. It's about the ethics of a company and whether you as a company want to actually go to the levels of Microsoft and comply with that. And we're seeing it even move towards potentially some organization using it as a competitive advantage. So to say, look, we don't even need to consider all these other legislations. We've taken the standpoint as a company that we're going to comply with the hardest standard out there possible. So I think
and your observation about the fact that people have basically come to the conclusion we have no privacy, that creates a sort of a cynicism, which is very counterproductive. I mean, going back to my cancer analogy, I mean, if every single building in California has carcinogens, how do we know when there really is a significant risk versus when the risk is so small that we probably ought to ignore it? And I mean, I think in the privacy field, there are some areas that people are worried about where the actual risk is fairly low. And I often wonder whether there's things that people are not aware of, are not worried about, where the risk is actually much higher. I don't know if anybody has any examples of those, but I always think that people have a tendency to worry about the wrong risks and stress over things that are either less severe or far less likely than the things that are more likely to bite them.
The big risk when it comes to privacy is that if we get habituated to giving control of our data away, we will lose the capacity to function effectively in a democracy. I think Julie Brill mentioned something similar to that earlier. But to control your data and to accept that you are in control of your data is to acknowledge that you're a self-determined individual, that who you are matters, and that ultimately you'd like to assert some kind of control over that.
Well, worrying about the demise of our democracy is very fashionable right now, so I'm glad somebody brought that into the conversation.
I think this is one of the things that, although California Consumer Privacy Act doesn't kind of go all the way, I think that kind of point exactly as you meant, at least it gives you some control. Although it doesn't have many rights in there, one of your rights is to deletion. So you do now have that right to go through, and if you wanted to, every single company send them a request and say, kind of remove my data. And it's interesting to see people are actually doing that. You speak to some organizations, they've had over 2,000 requests within the first week of CCPA going into effect, whereas others have had 2. So it's interesting to see that although there's still a way to go with kind of privacy and getting it involved, at least the first right to delete your data and have that removed is kind of there with that.
So we have just over 5 minutes left, and I do want to open it up for questions and comments from the audience. So feel free to jump in. Oh, yes, sir. If you identify yourself, please.
Can you hear me?
Yeah.
Okay. Question I have, real quick one.
Mind identifying yourself, sir?
Oh, my name is Paul Starrett. I have a firm. We work in AI.
Unless you want to exert your privacy.
And that's why it's going to be my question, but I didn't. Specifically unstructured data. But my question is that given the cost of finding sensitive data for data workflows, things like that, given the volume and complexity of data, I've heard it said that if you don't use AI, you might be substandard. Just wondering if you think that that's true, because it's cheaper, it's faster, and if not, what's the barriers to, just the general idea of that at all. Thank you.
Yeah, I think I've seen kind of 2 points to that is, firstly, I think privacy has tended more from what was traditionally just technical links. So if you looked at data mapping before kind of privacy regulations, it was very much the IT department saying that here's the link between this system and this system. Whereas what I'm seeing a lot of organizations go through now is really getting the business involved to tell them that information as well. So as you say, if you're going to start doing scanning of all your unstructured data, it's going to take a long time, and things like AI platforms are really going to help you with that. But I also think there's a second piece, which is really getting the business involved as well, which gives you more context, and although not the technical fields that are in your systems, it might bring out some of that information as well. So yeah, I think there's kind of definitely two pieces, and obviously things like AI platforms really help with finding data, but also getting the business to tell you where that data is an important piece that I've seen.
Do we have any other questions or comments from the audience? Yes? Nope? All right, well, I'm being told that we are out of time. I want to thank our panelists, Tom, Thomas, and Stacy, and thank the audience. Appreciate your attention.
Thanks, everybody.
Please welcome Julie Brill, Microsoft's Chief Privacy Officer for A World Without Privacy.
Hello. I have a lot of microphones here. I'm not sure which one I'm supposed to use. What's supposed to be happening here? I've got many microphones. I'm using one microphone. All right. Hi, everybody. As was mentioned, I'm Julie Brill, and I'm so delighted to be here for Data Privacy Day. 10 years of remarkable technology innovation have given us so many undeniable benefits. New ways to work, new ways to find information, and new ways to treat diseases. New ways to understand the world. All of it possible because we can now capture, store, and analyze so much data. But a lot of that data is about us, creating an incredibly detailed and indelible record of the most private aspects of our lives. Along the way to this technical revolution, it seems we've unwittingly made a trade-off: experiences that are more personal, convenient, and more immersive in exchange for information about what we like, where we go, how we feel, who we know, often to be used in ways we don't understand or even know about. Now we're grappling with a crucial question. How do we provide people with the privacy they want and the immersive digital experiences they have come to expect and even love? One thing we do know, the line needs to be redrawn because we are not okay with what, in too many cases, is happening with our data. We are not okay with a website where kids can make short videos of themselves, lip-syncing to their favorite songs to post for anyone to watch. That also requires them to provide their full name, email address, phone number, a picture, and a short biography, and make all that information public and publicly available by default. We're not okay when the television in our living room captures second-by-second information about everything we watch and associates it with information about household members who also might be watching, including information about age, marital status, income, education level, and sells it to third parties without our permission. And we're not okay when life insurance companies, again, life insurance companies, predict our health status by sifting through the digital records we leave of the pictures that we post online, the activities we engage in, the purchases we've made, our social media history, and our location data. We're not okay when the fertility tracking app that we use to record the details of our reproductive lives, our menstrual cycles, our sexual activity, medications, and our moods, sells all that information to our boss and our insurance company. And we are not okay when a little-known startup scrapes our photos from around the web to provide real-time identification to police and to others. These are all real-life examples. A couple of them have been the target of FTC action. The rest are simply a reflection of what is happening in the world we live in today. Now, I'm pretty sure that we'd agree that all of these practices cross the line of decency and respect that companies must honor to earn our trust when it comes to privacy. In 1997, the FTC held 4 days of hearings on how to preserve fundamental human rights in the post-industrial age. In the throes of a heated debate between civil libertarians and business executives, one of the FTC's commissioners asked, "Where should we draw the line?" As Shoshana Zuboff pointed out in the New York Times earlier this week, that line was never drawn. More than 2 decades later, the issue of how much privacy we have and how much more we need has taken on renewed urgency. In our digital world, progress and prosperity depends on trust. But today, in the face of a growing backlash against the technology industry because of revelations about the misuse of personal data, trust hangs in the balance. We know that our most sensitive data about our health, our reading habits, our religious beliefs, and our location throughout the day has become a commodity to be bought and sold in an invisible marketplace. And we know that our data is being used to target us in cynical and dishonest ways to sway our opinions, manipulate our beliefs, and influence our vote. In order to effectively address these issues, we must return to first principles and recognize that privacy isn't simply a human right. It is a foundational right on which all other human rights are built. Without privacy, there can be no rule of law. Without privacy, our ability to question our government and to protest injustice is lost. Without privacy, democracy cannot function. From Twitter to Instagram, Facebook to Snapchat, and well beyond, so much of who we are and how we understand the world is shaped by our interactions and experiences in the digital world. All of it captured and stored in digital form. 130 years ago, the great American legal thinker, Louis Brandeis, said that technological advances of his time had invaded sacred precincts of private and domestic life and were threatening the right to be let alone. Now, instead of demanding the right to be let alone, I believe that we've shifted to an understanding of privacy that must embrace 2 critical concepts: the ability to use digital tools and technologies to engage and communicate freely, and the ability to maintain control over how our personal information is used and to be secure in the knowledge that companies are accountable for safeguarding our data. I firmly believe that we can do both: preserve the right to privacy and enjoy the benefits of technology innovation. But to achieve this, people must have meaningful control, and companies must accept responsibility to be accountable for how they collect and use personal information. Both are essential to truly protecting privacy. The solution is also equally a matter of law and a matter of technology. And the good news is that we are making progress on both fronts. GDPR signaled the beginning of a global movement to adopt privacy laws that strengthen the right of consumers to control their personal information. The California Consumer Privacy Act is an important step forward, a step toward more robust consumer control over the collection, use, and sharing of personal information here in the United States. But more remains to be done. The imperative to enact strong privacy protections to draw the line has never been greater. Such legislation should offer baseline rules that focus on how data is collected and how it is used. They should require more transparency for data brokers and provide specific protections for sensitive data. Legislation should also regulate new technologies such as facial recognition, and it should be flexible enough to protect our privacy in a world of ambient data collection that is quickly emerging from ubiquitous connected devices that make up the Internet of Things. While enacting a strong privacy law is critical, we must also start to think about privacy more holistically and integrate our efforts to preserve privacy with our work to protect consumers and to preserve competition. We should ensure that consumer data use does not become data abuse through the targeting of our most vulnerable citizens, particularly children and the elderly. Now, at the same time, it's important that we think about privacy, that as we're thinking about privacy as an imperative, we also should be thinking about privacy as an opportunity. It's an opportunity that begins with approaches that fully embrace privacy by design, by making privacy protections the default in every business practice and technology across every aspect of how information is collected, stored, processed, and used. And we can do more to seize this opportunity by making the drive to advance innovation and privacy as central to what we do as the drive to advance innovation in every other emerging technology. But even with new laws in the United States, comprehensive privacy by design, and more deeply embedded privacy-enhancing technologies, we still need to acknowledge that data doesn't recognize national borders, and privacy protection is an issue that is fundamentally global in nature. Dr. Martin Luther King Jr. famously said, "A threat to justice anywhere is a threat to justice everywhere." So too with privacy. A threat to privacy anywhere is a threat to privacy everywhere. As we move forward, we need to work toward an international understanding of how we will implement this basic human right to privacy in our digital world. Now, I know achieving this won't be easy. While the need for privacy is fundamental to every human being, how we translate this need into a right that is protected by strong laws and technology will vary across cultures and across nations. Working through these differences around the world will require a slow, careful, and deliberative process to establish global privacy norms. But the benefits will be more than worth this effort. So, where do we draw the line between privacy and innovation? I think we can all agree that it is not okay to share the names and addresses of children under 13 with millions of strangers. And that if the website we use to keep track of our reproductive health provides that information to our boss, there's no doubt that we will feel rightly violated. Here in 2020, let's finally embrace this critical task of drawing the line. Let's embrace it in a way that recognizes our relationship to technology and to privacy are deeply entwined. Let's embrace the reality that our task must include a framework of laws and technologies that guarantee individuals the power to decide what information they want to share so that they can draw their own line. A framework that also gives people the security they need that comes from knowing that they are not alone in this endeavor, because companies will honor lines that simply cannot be crossed. A framework that gives companies both the ability and the responsibility to respect individuals' decisions and serve as trusted stewards of their data. Clearly, we're not there yet. But if we work together, we can create a world where privacy is honored today and send a signal to future generations that as technology continues to advance, the right to privacy must always be protected. Happy Data Privacy Day.
Please welcome Sean Martin, founder and editor-in-chief of ITSP Magazine, and panelists for Going Beyond Privacy Compliance.
Got our moves down. This is much easier than the other chairs, so.
All right, are we really standing?
I guess we are. Is this a bring your own chair event?
Is it bring your own chair? Bring your own chair.
Let's bring our own chairs.
Super. They're on the way. All right, we'll wait for the chairs. Well, while the chairs are being placed, a quick word. Thank you to Kelvin Coleman, Jennifer Cook for putting this on. Great event. I'm honored to be here, and ITSP Magazine is proud to be an ally of NCSA and supporting all the work that they do with respect to security and privacy, raising awareness and getting people and companies to take action. And I get to stand. Look at that. I'll stand. I prefer to stand, if that's all right. All right, so here we are. We've had a full day. We're coming up to the end here, so before Kelvin's closing remarks, just a few more conversations, and I'll call it operationalizing privacy, if that's all right for everybody. We've spent the day talking about what privacy means, and a lot of it's been around regulation, laws, and getting companies to do the right thing. So the question is, are the companies going to do the right things? Are they going to protect us, protect our privacy, or are we going to see a different outcome? And so we're kind of looking into the future here. So I know my co-founder, Marco Ciappelli, is joining us online digitally from Italy. He's not able to join us here today. He and I like to turn on our ITSP Magazine time machine to kind of look into the future a little bit. And we're going to do that here today to kind of figure out where privacy is heading beyond compliance and how can companies and citizens take action. So Marco, flip the switch, turn that time machine on, and let's go. And my fellow time travelers today are sitting here. We're going to take a journey and navigate privacy. Have each of them introduce themselves, starting with Ben, please, on the end.
Sure. I'm Ben Moskowitz. I'm from Consumer Reports. I head up our digital rights program called the Digital Lab.
Kalinda, Rana, head of global privacy at LinkedIn.
John Giverts, the Chief Privacy Officer at Visa.
Christina Bergman, founder and CEO of Integris Software.
All right, well, thank you all. I know we're going to have some questions at the end, so get them ready. This is the panel to ask them of. Really, to kick things into gear, I mean, let's look at the scale and the speed of these regulations that are coming out. How do companies get a grasp on it? I know some of the previous panelists touched on some of these points, but we'll start with companies first, and then we'll look at the consumer end of it. How do companies get a handle on this? Where do they start? Do they just dig into GDPR and hope for the best, or do they go with CCPA, or is there a whole different approach that companies should be looking at?
So I think for companies, one of the things we've seen develop over time is the profession of privacy and the fact that companies are beginning to build out privacy teams. And those are often lawyers who are sitting down and reading these laws in their entirety. And once you've read the laws, the next step really is to go out and talk to other people in the company who are going to help you to implement those. So I think what we're beginning to see is that while it takes the lawyers to interpret these laws, it takes a whole host of people within a company to actually get the work done and to put these into operation.
And I certainly agree with what Kalinda said, but I think if we are in a position where we are looking at each new law as it comes down the road and trying to comply with it, we're behind the curve already. If you come from a company where trust is a core value, and it has been, and you attempt to build on that value, you build on that foundation by making sure that you are protecting consumer information, by making sure that consumers have the right knowledge and ability to control the information that you collect about them, you're going to be in a better place as you strive to comply with just the vast number of new laws that we're facing. It's at a faster pace than any of us that have been doing this for a long time have ever seen. We have GDPR, and it was only, 19, 20 months ago now. CCPA is almost a month old. We can celebrate the month birthday in 3 days. And there's more and more that we have to do. So building a program, as Kalinda indicated, that covers the spectrum of values that are inherent in any company and inherent in a consumer-focused or individual-focused approach, I think is critical.
Something we've seen in +1 on both comments, something we've seen a number of companies do is put together a governance council for GDPR and CCPA that spans lots of working teams. It usually includes the CISO, the CPO, head of risk, head of governance, head of lines of business, and occasionally the CEO themselves. And typically each of those heads owns a work stream, which is a component of compliance with these privacy laws. Obviously the privacy team owning the legal side and interpreting the laws and helping translate that into business operations. But the data governance team, how do you understand your data in order to comply with this and know what you have? The security team, how do we operationalize the controls that we then take from the data governance team and then implement with the security tools? And there's a whole continuum that we see go down the line, but we have yet to engage with a customer that doesn't have multiple teams across multiple divisions working together, and very senior leaders across the entire team heavily invested in figuring this out and making it part of what they do on a day-to-day basis.
I don't know, Ben, if you, obviously, you're looking at this more from a consumer perspective, but do the consumers care whether it's led by compliance or not?
Well, I think a lot of what we've talked about today, ideally a consumer would never need to think about. We handle that complexity for them. But I do think that consumers care to the extent that privacy is a social issue, which I would argue it is. I saw a poll that said that consumers think that privacy is the most important social issue by plurality. So 65% of people in this poll said it's the most important issue they want companies to address. It's above climate change and everything else. I wouldn't go that far necessarily, but they clearly do care. And I think that they want to be able to trust that companies are doing the right thing.
And so are they looking for CCPA compliant or GDPR compliant on websites and in applications and products?
Probably not yet.
I think it goes more to what John's point was, which is an expectation that the public's beginning to have of companies in the way in which we act, the way in which we talk about these issues and the way in which we think about these issues, and that the law is not the first thing that is prompting us to do the right thing. The companies, similar to Microsoft, similar to LinkedIn and Visa and other companies, are already thinking about these issues, have the framework in place, and are in some sense ahead of the laws because of the way that we've built our systems, the way that we have talked to our workforce about these issues, and just the underlying values that the companies hold and stay true to. And I think that's sort of a shift consumers have to make, is beginning to evaluate companies on those things rather than just privacy policies, which we've heard from other panels are long and hard to understand and often say things that are often frightening. It's really getting consumers to take a more active role in evaluating the companies they're working with.
Right, and just to add, when it comes to CCPA, as we know, it's new, it's brand new, and it's not clear to a consumer how you exercise these rights. So we know that CCPA right now is a bit of a first draft, we're all learning. I think that it will be interesting in the future to see if there are trusted intermediaries or tools that can help consumers exercise rights like the ones granted to them under CCPA.
Yeah, and what I'm really trying to understand is, and clearly some of the large organizations have the benefit of a culture of building trust, right? And the resources to build out platforms and processes and teams to actually ensure that that happens. And it's essentially a culture. I know one of the things we want to talk about is the culture. How does a smaller company faced with the onslaught of these things where security and privacy are kind of second nature, they're just focused on their business, how do they begin to build that culture with privacy and security first and trust at the core of what they're doing?
So I think it begins with setting the values of the company from the beginning. I think for a lot of startups, there is a point at which you're making a choice about how much data you're going to take in and how you're going to use it, and actually whether or not you're going to make the choice of doing the hard thing with that data. And I think a lot of this also comes down to the Silicon Valley at the point of going and getting additional rounds of funding, at the point of deciding where that company is headed. Some of those advisors actually asking the questions about how did you think about data? How did you think about what you're doing here? What are your corporate values around that issue? And I do think that when companies are being acquired, that is something that is being looked at. So I think that that's beginning to happen.
There's actually a very real story I can tell. And I will not tell you which company this is for reasons that will become clear. But basically, there's a large organization that's one of our customers. They acquired a smaller company. And during that acquisition, they were a tech startup. During the acquisition, the executive team and board made all sorts of attestations about what data they have, what data they don't have, what kind of personal information is there. And for anybody, I used to work as a venture capitalist before this. For anybody who's kind of been in that world of M&A knows that attestation around privacy is getting longer and longer and longer and longer as acquiring companies want to know more and more and more about the data that's going to be coming into the system. And so this company, when they acquired the smaller company, the board, the executive team said, no, we don't have anything we shouldn't have. It's all good. Don't worry about it. Jedi mind trick. This is not the bad data you're looking for. And post-acquisition, they dumped it into their Hadoop cluster. And big data technology, Hadoop, is typically a dumping ground for all sorts of things. Everything just ends up in there. No matter how locked down it is in another system, it ends up in your Hadoop cluster. And we came in and ran a scan through their data set, and we said, did you know you have adult content? And the CTO was sitting there with his jaw hanging down looking at it. And we showed him a couple of examples of what was there sitting in his Hadoop cluster. And the chief privacy officer was sitting at the back of the room, rocking back and forth, smiling, having an I told you so moment, because they had been pounding the table of, we've got data we don't know we have. We need to find out what's there. If we get breached and it's out there, we're liable. Our brand is at risk. Our reputation's at risk. We need to know what's there. And this was her I told you so moment. And after that, it was, okay, well, where exactly is it? Which data set? Who put it in there? The forensics that go back. And the reason that becomes relevant is not just in terms of risk profiling, in that the risk of the small company becomes the risk of the big company, which is a much bigger number when it's the big company, but also in terms of, in the event of a breach, you're probably also going to get hit with any kind of privacy law violations that are in there along with that breach. And so I do hear a lot from folks of, there's only 3 people in California that are going to be enforcing these laws. And I think, okay, well, maybe for now, but also guess where they're going to start? They're going to start with A, publicly known offenders, and B, they're going to start with people who get breached and go and look at them for privacy violations. So you really need to have your house in order.
I think it's a great story, and I think...
You cringe?
Never. But I also think it goes back to, the initial question, your initial comments. small companies are not necessarily going to have those huge compliance departments, legal departments, auditing functions, and the way that they get to where they need to is also to have it cultural and to be looking at not the size of the organization, but to look at some of the tools that we all use and the approach that we all have and the ethical considerations that we have. So you do your data mapping, you do privacy by design, you think about what data you're collecting, how you're using it, do you have the right controls around it, because that's how even a small company can be effectively manage privacy risk.
I think all this is a way of saying there's no time like the beginning. If you're an entrepreneur today, I would think of dealing with privacy as a form of technical debt that's going to get more expensive the longer you go on. And it feels a bit like if you're a new company starting today, you can afford to not be reactive in the way that a big company needs to be compliant. You can do privacy by design and maybe find some white space in the market to create a product that's maybe differentiated and really appeals to what we think is a growing consumer sentiment and a need and a want for privacy. We're working with the Omidyar network actually on this exact question. We're doing public opinion research, we're doing surveys, trying to find in what categories, if you do a forced ranking of the things that make consumers pick their products, in what categories might privacy be near the top, such that if you can really differentiate your product and say, this is a much more private product, that will make the difference in the marketplace. So I think that's a really interesting place to be if you're an entrepreneur today, is thinking about to go into your time machine and 10 years hence, what's the kind of world that we're living in?
Well, when we say privacy by design, I'm not going to let anybody off the hook here. What the heck does that mean? How did we do something with that? I mean, I kind of know, and it's security by design. We see movements like DevSecOps. Do we need to see a DevPrivOps movement?
So I think privacy by design means different things to different people in an organization, and that's a good thing, because really what you want is everybody in the organization to see it as part of their job. So I think from an engineering standpoint, it means applying engineering principles to product problems to find out, how can we do this with less data? How can we anonymize this data? How can we find ways to isolate it so that only certain people have access to it? So thinking through some of the engineering techniques. I also think it applies to product, and I think product people thinking before they put something out on the market, working with the engineers and the lawyers, but also thinking themselves, is this a product that people are going to react to in a way that makes them uncomfortable? Is this something that does a good action and helps people solve a problem and gives them options for thinking of how they want to protect their privacy, rather than just putting out the product and not thinking through ways to help people control their data? So I think actually within an organization, everybody plays a role, and that's something that I try really hard in my role to get across throughout our organization, is that privacy is everybody's job, and it is really everybody's job to be thinking about it from a design perspective. Even if you're someone sitting in the finance department, there are pieces of what you do where you may not need all the data you have. You may want to make sure that only certain people in your department have access to it. So having everybody think about it in the way that they do their job.
I couldn't agree more. And so certainly, but this is also an area where a larger company can distinguish itself from some of the things that smaller companies can do, because everybody should be doing privacy by design and building it in, as we do in security by design, in the earliest stages of thinking about development. As we're doing agile development and we're doing our sprints, everybody has to understand concepts such as data minimization, data transfer, et cetera. But you also need, and I think to support this culturally, having operational processes that reinforce that. So having formal PIA processes and reviews that make sure that those steps have been undertaken and the right mitigations are put in place where they're needed. And one of the things that we also do at Visa is we have a cross-functional data use council with senior executives from across the business, where we take, if it's a new kind of use of data, if something that we haven't done before, we're looking at that. It comes to that council and looked at from that perspective. Is it, not only is it the legal thing to do, because we have lawyers, we can answer that question, but is it the right thing to do? Does it embody the values that we try and get across about security, consumer control, providing value to consumers.
Right. I mean, there are probably forms of data collection that the consumer doesn't want, need, expect, does not enhance their product experience. I'm thinking, for instance, of an antivirus that might sell your web browsing history. There ought to be some lines drawn, I think, as Julie put them, where we can say, you know, this is more about the business interest of the company, about building a good experience, which is, you know, how the market ought to work.
And I was just going to add on, I agree with that idea of lines drawn, and I think that is something that any company at any stage can put in place, is where are the lines of what we're going to expect. The other thing that I might be a bit controversial in just arguing for is that I think a lot of what we've heard today is a resource constraint around people who do privacy. And I think one of the things we need to start thinking about with privacy is that it's not just the people in this room who should be doing privacy. We need to be training the future workforce to think about this issue, even if they are not a lawyer or a privacy engineer or someone else. We need everybody to be actually having a baseline understanding and expectation, to your point, of what is that line as a society that we will not cross, and to be educated at some basic level about that. When I was in law school, privacy wasn't even a topic of discussion. There were no classes on privacy. Undergraduate programs today don't have any discussion on privacy. MBA programs don't have a discussion on it. And I do think if we're in your time machine and we're thinking about the future, and our expectation is that even at a startup level people can do this, we need to be training more people to do this work.
Well, it's easier at the startup level. I think if you have established systems and processes and a culture that doesn't embrace trust and privacy, it's probably even harder. So how, maybe looking at both angles, how does a company that is dealing with building a culture of that's surrounding privacy, how do they do that? Is it top down? Is there a champion inside that isn't at the exec level? And then maybe from an SMB startup perspective, how do they lead that culture establishment, if you will? Who leads it?
I'll jump in. It's got to be both. It's got to be bottom up and top down. I mean, at Visa, we're fortunate enough to have leadership, and our CEO was just speaking on data values very publicly, and that's a great place to be, and that people in the company understand that. But at the same time, it's also making sure, and Kalinda, your point about training, it's people that are coming up, the people that we're hiring. It's awesome if they have a background in understanding these issues. I think we have a cultural understanding more and more around breach and the implications of losing data. I'm not sure we have that same cultural understanding around these other concepts about data collection, about transparency, and so forth. So making sure that we're having those conversations both within our companies and at events like this, and at events that are much broader, that aren't only geared to privacy professionals.
And maybe as you answer, if you can make some examples. Do you run campaigns inside? Do you have data privacy days or weeks or luncheons or whatever? I don't know, any examples you can share as well?
I was just going to comment on John's point that I think it really depends a bit on whether it's top down or bottoms up on your culture within your company as to what works best. But I think some of I actually teach a course on how to build a culture of privacy, and some of the things that I think have been most effective is getting people, again, not the folks in this room, but impacting the people outside this room to understand how privacy impacts their daily life. So for example, at LinkedIn this week, we are celebrating Privacy Awareness Week. We had an event yesterday for parents at LinkedIn on how to protect your kids' privacy. We have events on how to protect your identity. We do events in our India office around the India Privacy Bill and some of the biometric data that's being collected in India. So trying to make it relevant to the employees in their own lives so that as they do their job, they recognize the importance for the people they serve.
And how about from the consumer perspective? Obviously, Data Privacy Day, Marco and I, we joke, it's not a day, of course, not a joke. It's every day. We need to think about this. So what additional things can we do for consumers, either from the business or in the communities, perhaps?
One thing we've seen a lot of our customers do is use it how they talk to their customers. So talking about the values of privacy, communicating that clearly. And I think you guys heard on the last panel, it's not uncommon for us to hear companies using it as a differentiator. You know, oftentimes you'll hear Facebook compared to Apple in their approach to privacy and what that means in terms of consumer trust and people's willingness to share their data and put more of their lives in the hands of those companies. And so I think a huge component of it is making it part of your storytelling externally. It obviously has to have basis in what you're doing internally, but we're finding more and more people are using that as part of their pitch to customers of why they should do business with them, why they should trust them, why they should share more data, and get products and services from them.
Take it one additional thought is we all strive to make sure that we develop our consumer-facing materials, whether it's our websites and so forth, to make them as good as we possibly can, as transparent as we can about our data uses, and provide the rights that are appropriate under GDPR, under Ccpa, and so forth. But I think it's also incredibly important to have discussions when we have industry groups and in industry meetings, to have discussions not only about, hey, what are you doing to help comply with Ccpa? There are lots of those discussions, we're all having them. But how do we get better as companies and as industry in having the right dialogue about ethics and values consistently with consumers to drive these concepts of trust and privacy?
The way we think about it is when you're shaping the market, when you're thinking about marketplace practices, you can draw a shape, which is a triangle. It's a lovely triangle. And at the top, you've got consumers, because we all want to build the products that are best for consumers. We want to compete on the basis of what's best for consumers. We're rewarded in the marketplace. So then on that bottom left-hand side, of course, you got the supply side, you got the manufacturers, the companies, you got the rule makers. Often when one of those sides of the triangle is out of whack, it's really hard to do the right thing. It's really hard to have a race to the top. So I think despite Ccpa being a first draft and imposing a huge compliance cost on a lot of companies, it's good in the sense that it sort of resets the incentives, creates some disincentives. And it's part of, I think, an overall effort that we need to have together, consumers, manufacturers, policymakers, to help put the right conditions in place so that companies are competing on the basis of privacy the same way they're competing on the basis of value and performance and security and things like that. So I think that kind of dialogue is really critical. And one thing that I would encourage everyone to do is, if you're interested in this kind of dialogue, we are working on something called the Digital Standard. And it's an effort to really articulate, well, what are the right norms and values when you're looking at products? Because some of this stuff, it's harder to evaluate than value or performance, and sometimes it'll be in the eye of the beholder. So I think that kind of dialogue can be quite helpful, and I'm sure that everyone would agree.
Well, that was a great segue to my next question, Ben, because taking culture and kind of flipping it sideways from the consumer's perspective, we have generational differences in expectations. We have international differences, right? Privacy in the US is different than privacy in Europe, is different than privacy in Asia. So how does a company understand those expectations from the individuals and from the global perspective and build a product and a service and maintain a culture that addresses all of them?
So there's, I mentioned I used to be a VC, and one of the things we used to do are these unconferences where you bring thought leaders in a particular area and discuss topics based on what they nominate. We had a fairly senior engineering leader who focused on security and sort of to bleed into privacy a little bit, give us some interesting details on the generational divide and the studies that they did. And this was about 10 years ago. And they thought millennials just don't care about privacy because they'll just share anything online and it goes out there in the ether. And so they studied this thinking, okay, are we going to have to figure out how to deal with a generation of people that just don't care about privacy? And what they realized was that as people hit about the age of 27, 28, they started to care about privacy regardless of their generation. They started to clean up their social media sites, delete photos, try and find things that had been posted before, take them down, look a little bit more serious. And they realized it's not a generational thing, it's an age thing, and it's an employment thing. And when people start to go out and look for jobs, employers go and look you up online. They'll search you, they'll Google you, they'll Bing you. And when they start to see photos of you behaving like a moron in college, they'll think, is this the kind of person I want to, let handle my checking account? And so they found that it's not generational, it's age. And then internationally, the thing that has been really fascinating to me is how privacy has become part of the social lexicon now. Many, many, many more people are aware of privacy and its implications because of what's been in the news over the last 4, 5, 6 years. Starting with Edward Snowden, then we had 2016 election, Cambridge Analytica. The hits keep rolling and these new regulations, and there's just a broad awareness of privacy, the importance of privacy, and how that impacts our very basic freedoms and our day-to-day lives that I don't think is going away. I think it will keep building. And I think the impetus is going to be on companies like us to make sure we're addressing those concerns in a constructive way.
Yeah, I mean, it's definitely in the zeitgeist, and it's probably a bit bizarre for everyone in the room who's a privacy professional or focused on privacy in some way to suddenly feel like you're working on the issue that everyone's thinking and talking about. But on the other hand, one of my favorite privacy stories is from 1991, when Lotus Software Corporation and Equifax said, we're going to put out a CD-ROM with 130 million households with their address and marketing information, and we're just going to sell it to whoever wants it. And there was a huge backlash, and 30,000 people wrote and said, no way, don't put my data in there, and they were forced to cancel the product. So in some ways, this is not entirely new stuff. It is a constant game of vigilance and making sure that the public is aware and engaged on these issues and feels that they have some stake or that they've got some ability to affect the outcome. I think the worst thing that could happen, and one of the other speakers alluded to this, is for consumers to feel like there's just nothing that can be done about it. That everyone's already got my data, this is too complex and scary, I give up. And so I think just going back to what we can all do, everyone on that side of the triangle, demonstrating a commitment, helping people feel empowered, doing things that really do put control back where it belongs, which is the consumer. I think that is something that we can all do.
And I think there's a misconception, maybe a tangent here, but data isn't just our name and address and email, right? It's where we are and how we work out, what that video looks like, right? A lot of metadata out there that we have to think about. Get your questions ready online and in person, I think. I want to bring it back to the operational piece as we wrap up here and wait for a couple questions. Are there any frameworks, processes, technologies, best practices that you found help you get a grasp on all of these regulations so that you can actually focus on the trust versus just simply being compliant?
Yeah, I think we've alluded to several. I think privacy by design is at its core. It's also understanding where the data is in your infrastructure. And you provided a perfect example as to one of the reasons why. But it's more than that. It's more than getting stuff that is finding that you might have something scary there. It's also just understanding the data and where it sits across the organization, across the enterprise, so that when you are providing control and choice and transparency, you're able to do that accurately and effectively.
I would absolutely agree with that. I think those are all the baselines that you need to have in your organization to get in compliance with what the laws are today, right? And then going the next step up means making sure that everybody is trained on what your value system is on privacy as a company and how you're going to approach it, both from a design perspective and from just continuing to chip away at the tech debt of companies, quite honestly, that were created in the 70s and 80s. Their concept of data privacy was what you just described in the Lotus Notes example. So trying to get, those companies have some of the toughest challenges, and I think that is actually helpful for companies today to recognize that if they don't stay on top of it, it's only going to get worse. And then from a global standpoint, I just wanted to touch on that question you were asking of how do you deal with the fact that a lot of us are creating products on a global scale, and the laws are different across the globe. And again, I think that goes back to the point John and I have been making of having a baseline standard across your organization as to how you're going to approach these issues, something that goes even above and beyond what the law says.
I think that's spot on. The one thing I would add on to it is automation, because there are certain things across every geo, across every business unit that you know are going to be standard. So for instance, you never want to have credit card sitting unencrypted. You know that. So if you ever see credit card unencrypted, auto-encrypt it. And so having tools in place that can discover those things on an ongoing basis and acknowledge the fact that data is not a static thing. It is constantly changing, constantly streaming in and out of your organization. It's a moving target. Having some automation in place to go and find those areas where you know you don't want to have those things, or you know if you've got religion information, like somebody's food preference, kosher or halal, that can tell somebody your religion. And so being able to find those things, put them in secure network zones, create some of that automation in place to help address these things in a programmatic way will help a lot, because the vast majority of organizations have way more data than they can possibly comb through doing anything manually. And so you have to have automated procedures and processes in place to grab those things that you know are going to be problems and auto-correct them.
Perfect. And question here from the audience.
Is that working? Well, yeah. Jim Dyer, I'm with a startup that works on privacy for news. Would like to know if any of you have any hero products or hero people that you read, absolute favorites that you go to for yourselves to stay in touch with these issues. Thank you.
So I will put a plug in for the IAPP. I will disclose I'm on the IAPP board, but I do find the International Association of Privacy Professionals, their daily newsletter, to be a really helpful resource in terms of keeping up on what's happening in the world on different privacy issues. Also, the New York Times is doing a great piece right now on privacy, so that's another one.
Yes, my name's Craig Erickson. I'm just an ordinary consumer. And my question for the panel is, do you exercise your own data privacy rights? If so, how would you rate the job that you're doing? And do you have any tips or advice for anyone else trying to do the same?
And go.
That was such a good question. Well, I have 3 kids, so I'm pretty busy keeping track of their data privacy. I would give myself maybe a B if I was grading myself. I think the way I keep track of it, I don't read privacy policies. It's just too hard. So I do pay a lot of attention to what apps I download. I do use Apple systems. And I think try to be very aware of your privacy settings and actually put them to use.
Hi, I'm Sylvia with the National Cybersecurity Alliance. I'm going to ask a couple of questions that we're getting through our live stream, if that's all right. On behalf of @CyberWise, there's 2 questions. What's the difference between security and privacy, and is there anything distinct about these 2 topics? And number 2, how should metadata be protected in the context of privacy?
So I'll take the first crack at that. The way we differentiate between privacy and security is that privacy sits upstream from security. Privacy will tell you what's important and why, and security is the how. So for instance, you have social security number streaming into your data set. You want to be able to identify what it is, why it's important. It ties back to a policy, and then the how it gets encrypted is where security comes in. When it comes to metadata, there's different types of data, obviously. There's the raw data itself, the metadata about it. One plug I will make is that the metadata can sometimes be wrong in structured systems. You can have credit card in a phone number column because of a bad ETL job, just FYI. So the way you treat metadata, the raw data, and then the derivative data that can be built from that is all different, and it depends on the classification of the data itself.
And one other question from a live streamer, Company 1121 asks, how do small businesses show they are compliant without breaking the bank? Looking at healthcare viewpoint.
Well, healthcare will set me off on a whole nother tangent because a lot of Americans think that the health data that they give to apps and services not associated with a healthcare provider or an insurance company is secured in the sense that it can't be sold and so on and so on. But we all know that that's not the case. So I know that wasn't the question, but I just had to say that again. That's a real loophole. It's a real gap in the law that we're going to need to address.
And I would say if you're a startup in health data privacy, having done health data privacy in a previous role, get a good lawyer who understands health data privacy. It is a complex area, and it is not to be taken lightly.
And it's important.
Dave Lurch.
Final question, I think.
Dave Lurch, I was wondering what your thoughts were on compliance and venture arms at large firms. So looking broadly at the ecosystem and structuring structuring innovation and how resources get placed within the R&D pipeline, and looking at privacy compliance and those issues from that lens.
I think privacy, we were talking a little bit about it earlier, right? I think that privacy is incredibly important at a cultural level as you innovate, because that's where we want to support a lot of tremendous innovation, whether it's using AI or other techniques that are valuable and will ultimately help consumers if we do them right. And so the challenge for all of us in the industry is making sure that we're looking at doing it right and putting the processes in place, whether it's the engineering processes or the security processes, so that when we do that at a venture level, at an investment level, we're building that in without that overhead of necessarily of a large compliance organization. And some, whether it's processes or some tools that enable that are scalable, right? Because we're talking about at the venture level, we're talking about things that are scalable, both downward as well as upward.
All right, and do I have time for one more? One more. Lan, how about it?
Thank you, Sean. So I'm not going to introduce myself, but in terms of the other question about how a small business can help themselves, and as we know, they do form the backbone of this society's economy. So one addition to potentially for them to consider is that right now there's a movement for nonprofits to actually help bring in the trained professionals who volunteer to work. And then also in the meantime, the nonprofit brings the students who are in school still to team up as a mentee. So there you have a team of experienced professional to mentor a unexperienced student, and together they can help the smaller businesses. By the way, local governments also love that. So the nonprofit that we are doing is expanding this program we have. One example is that Cisco, they already have such a program to encourage their employees to volunteer at the community for like 1 week, paid 1 week to help. And so we have volunteers from Cisco to work with us, through us, and Cisco also match some funds to our nonprofit. So in the end, you create a win-win-win for everyone in this program. So I just want to inform everyone about this program right here, and we're seeking to expand it nationwide as well. Thank you.
All right, so no question. Just
sorry,
sales.
Sorry about that. But oh yes, since you reminded me,
No, I'm going to stop you, Lan. Sorry. I'm gonna stop you. Thank you for that information. No, come on, please.
Oh, sorry.
We're out of time.
Oh, yes.
We're out of time. We'll talk offline, Lan. So with that, we're good? Good. I'm just going to say a call to action as individuals. I mean, this can be overwhelming, right? We've talked about a lot of stuff today. It's not difficult if you take one small thing and take action. Pick one social network and check your security privacy settings. Do that today. Do another one tomorrow. Then it's not overwhelming. And then for businesses, same thing, right? Don't be overwhelmed with all the different regulations and all the technologies and do I have a culture or not? Just pick one small thing and do that tomorrow. So with that, I want to thank the panel for a great conversation, and thank you all for joining us.
Please welcome Kelvin Coleman, Executive Director of the National Cybersecurity Alliance, for closing remarks.
To Kalinda, I had to introduce myself. I didn't get the voice of God, but it happened. So, yes, you got it for me. My name is Kelvin Coleman. I have the pleasure of being the Executive Director of the National Cybersecurity Alliance in Washington, D.C. Thank you so very much for being here today at LinkedIn for Data Privacy Day 2020, a vision for the future. And thank you to all of those who joined us online. For those who do not know, the National Cybersecurity Alliance is the nation's leading nonprofit, public-private partnership promoting cybersecurity and privacy education and awareness. And for many, many years, Data Privacy Day has been a key part of our education and awareness efforts, and we're so thankful to LinkedIn for having us here today. I think Craig Erickson, I think I pronounced that correctly, asked a great question. He said, I'm just a consumer, right? And I want to know X, Y, and Z. That's why we're here today. And Kalinda said as much. It's not about the professionals who are in the room. It's about the customers and the people and our kids that we're trying to really drive home this message of privacy. Thank you to all of our speakers and our panelists for sharing such engaging insight about the rapidly evolving privacy landscape. I also want to thank our contributing sponsors, Microsoft, Visa, MediaPro, Integris, OneTrust Privacy. Thank you so very much. Our global sponsors, Trend Micro, 3M, KnowBe4, Yubico. Thank you so very much. And our event partners, ETSP, and certainly Identity Theft Resource Center. Thank you very much for helping us out here today. Would not have been able to do it without your help. Also want to thank Alicia from LinkedIn. Can you stand for a second, please? Everything from helping to put together the agenda, talking points, literally moving chairs, right? Like that's someone who will do it all. So Alicia, you and your team, thank you so very much for everything. I could not go without thanking my wonderful team, the National Cybersecurity Alliance. Here with us today, Daniel is here. Elliot, I think he's downstairs still. Sylvia, who just joined us as our COO. Leighton, so very happy to have you on the team. Jen, I'm going to have you stand for a moment. At the National Cybersecurity Alliance, we often have quarterbacks for different projects and programs. I'm often not the quarterback, believe it or not. Jen, for this, you did such a wonderful job. You were the best quarterback ever. Look at this overflow room. Again, I'll go back to Kalinda's words in that this is getting bigger and bigger every single year. And thank you for helping this put together. You and Alicia did a great job. That's it. Today's event is just made possible with support of all of you. And I want to thank you for being here today. Please, you can find us. Oh, I thought my handle was up there. But the National Cybersecurity Alliance, please join us on our Twitter, our Facebook, and we have a few other things there. So join us. Hey, thank you very much, and we really appreciate you being here today.